In the third object, we have two specific words, mischief and criminal trespass. And it is these words are followed by the general expression other offense. In such a situation, when the question of interpretation comes, then the scope of the general term is confined or is restricted by the specific terms which precede it. So as per this principle, the term other offense should be restricted to offences of the same kind which are mentioned earlier: offense of mischief, offense of criminal trespass. It should be an offense against property. For the isustem rule to apply, the specific words must constitute a category, class or genus. If they do constitute such a category, class or genus, then only things which belong to that category, class or genus fall within the general words. The specific words in this case constitute a category of offences against property. So, can we say that the general words other offence will be restricted only to offences against property? If the isustem rule is to apply, that will be the interpretation. But then, the isustem rule cannot apply in every case. This is just a rule of construction and it has to be applied with caution. What is the primary rule? The primary rule is that statutes are to be construed in accordance with the intention of Parliament. So what matters is what was the intention of the legislature when this particular provision was inserted. Once again, we take recourse to the Supreme Court judgment in Vinubhai Patel versus Rajiv Bhai Patel, decided in 2018, to understand the scope of the expression other offence in the third object of section 141. The court says the words falling under section 141 clause 3rd, other offence, cannot be restricted to mean only minor offences of trespass or mischief. If that is so, then the rule of isustem generis does not apply in this case. As per this judgment, the expression other offence cannot be restricted to mean only these minor offences of trespass or mischief or similar minor offences against property. And this is the statement of law declared by the court in this case, which is of vital importance for all of us. These words cover all offences falling under any of the provisions of the Indian Penal Code or any other law. So the scope of the term other offence is as wide as possible. It includes any and every offence, not only under the Indian Penal Code, but also under any other law. Now, what is the meaning of the term offence as it appears in section 141? Other offence, we have understood other offence means every other offence. But what exactly is meant by the word offence? Now, as we saw earlier, the meaning of the word offence is not the same in every section of IPC. Its meaning varies from section to section. The word offence has been defined in IPC in section 40. There are 3 paragraphs in that section. And we have to see as to the definition of which of these 3 paragraphs will be applicable to the word offence as it appears in section 141. This is the first paragraph of section 40, which says that the word offence denotes a thing made punishable by this code. But this definition applies only to those cases which are not covered by clauses 2 and 3. So first we will have to see whether section 141 is covered by any of these 2 clauses. So here is the second clause. The definition of this clause is wider than the first paragraph. It says the word offense denotes a thing punishable under this code and a thing punishable under any special or local law also. But this definition applies only to certain specified chapters and sections. Section 141 is not there in this paragraph. Therefore, we move ahead to the third paragraph. And here in the third paragraph, the very first entry is section 141. So, the definition given in the third paragraph will be applicable to section 141, and the meaning of the term offense in section 141 will be as under. Firstly, a thing punishable under IPC. Secondly, a thing punishable under any special or local law where the punishment is imprisonment of 6 months or more, which means that as far as IPC is concerned, every offense is covered by the term offense under section 141. But as far as other social, special or local laws are concerned, only those offenses are included within the definition of section 141 which are punishable by 6 months or more. If the punishment for any offense is less than 6 months, then it will not be covered by the term offense as it appears in section 141. So now we can say that if the common object of an assembly of 5 or more persons is to commit an offense under a special or local law which has prescribed for it an imprisonment of less than 6 months, such a common object will not be unlawful as far as section 141 is concerned. Such an assembly will not be unlawful assembly. In other words, if the common object of the assembly is to commit an offense which is punishable under IPC, it is unlawful. If the common object of the assembly is to commit an offense which is punishable under any special or local law with imprisonment of 6 months or more, the assembly is unlawful. But if the common object of the assembly is to commit an offense under a special or local law where the punishment is imprisonment of less than 6 months, that assembly is not unlawful. So this is an important point which must be carefully noted.